Hey, what's up, guys? What's up, guys? Welcome to Lawsplaining the Interwebs. I'm your late but hetero host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And oh boy, it has been a couple days, man. And I do apologize for the couple days. I'm dealing with all sorts of fun stuff at home. I'm not going to sit and whine about it because it's not whine worthy. I'm just busy, right? Just busy. Busyness is good. But I'm sure many of you have seen that appeals are happening. Appeals are happening, is what I'm told. Of course, we do not have a filing yet. So for now, appeals are going to happen, and eventually appeals will be actually happening, I suppose. There's a little bit of a difference there. But I am told that a filing is coming, maybe even very soon. There's a bunch of steps to the appeals process, and I am far from an expert on that. So I'm not going to talk about the procedure of the appeal so much. Because I don't want to sit and pontificate on what it might be. I don't know the process for appealing a case in Texas, and I can get maybe I can either get an expert on that maybe even someone detached from the case who would be interesting to meet. I don't know, or I can get kind of a primer, a rundown of how it's done, of all the steps, review the rules, and bring that to you. I'm not sure how I'm going to do it yet, but it's not, I'm not going to just run into it, right? And try and explain it out of nowhere. Why? Autofocus, man. Get out. Be gone. Be gone. But I'm not just going to run into it. Instead, how I'm going to start off with this stream is we're going to, oh my goodness, we're going to stop itching. Holy cats. The temperature changes, man. Whew. Sorry. We're going to start just tackling the actual paperwork and start tackling the appellate arguments. Right? So this is a de novo review, which means that the appeals court looks at it from a blank slate. They look at what's in the clerk's record and they go kind of from there. So we know what's in the clerk's record. We know what Chup's order was. The way the appeal will basically function is almost like a rehearing, although very, very different. It'll be a rehearing, but not a do-over. And the briefs for each party are limited in words, so they have to really carefully pick what they're going to go after. You don't get to sit and spend paragraph after paragraph slagging the judge's terrible decision or his poor opinion or whatever. You don't get to make fun of a guy who sucks lemons through a straw. You don't get to waste a bunch of time doing that. The appeals court doesn't have the bandwidth for it, and they don't have a tolerance for it. And then when you get to oral argument, it's a much more limited oral argument. It's much more limited in the fact that it's you have a strict time limit, which is much shorter than anything you would get in the district court. So we're gonna, how do we do this? In just a little bit, I'm going to pull up the opinion. We're going to go back through the opinion There's not a lot to go through. And then we're going to start trying to see how they're going to attack each of these things. And I think the best way to do that is to bring up filings in the case. Because like I said, one thing we have to have for an appeal is you have to have the evidence that you need in the record. You can't have the evidence you need show up at the appeals court. You had your chance to file it. Now you don't get to add to the record. You don't get to add to the record. That doesn't mean that everything that's in the record will be at the appeals. And it doesn't mean that things that were ignored by the trial court won't be in the appeal. Specifically, those will be some of the arguments. So, with that said, we're going to delve into that in just a minute. Hold on. Whiskey. We're going to delve into the opinion in just a minute. And then, but before that, I'm going to address a couple things with the approach to this. Because as an approach to appeal is different than the approach to trial court, my approach to the appeals will be different than my approach to the trial court. Seems normal, right? I'm not gonna, well, let's start it this way. There's a lot of hype going into trial. There's a lot of hype. There was obviously a lot of hype on this channel. I don't know. Some people may agree or disagree with the level of hype, and that's fine. It's done how it was done. But that said, trial is about the big opener. It's about going in, making your case. Appeals, especially appealing a loss, is where you have to come back with some reflection, with some analysis. You have to talk about why the trial court was wrong. You have to kind of do it while respecting the court. Attempting to respect the other side, that's not going to last long, I don't think. But you have to come at this thing a little bit differently. And reflecting that, not only is my personal approach going to reflect that, but the type of documentation we're going to get is going to reflect that. It's going to be less, there will be less venom in the filings, I'm guessing, from both sides. It's going to be much more analytical. The appellate court is far less concerned with the appearance and the posturing than even the district court. And the district court is supposed to be unconcerned with it. Now, was Judge Chup unconcerned with the greater narrative outside of the case, the extrajudicial action going on in the case? Was Chup unconcerned with that? I don't think he was. And I think that might be a violation, not of a particular duty that the judge has or of any ethical rules. Don't get me wrong. It's a violation of his own professionalism. His job is not to worry about the healing of the anime community or whatever garbage he was eating off of Monica Rial's disgusting table. That's not Chup's job. His job is to apply facts to law, not try to heal a situation, not try and calm down a bunch of people who, remember, Judge Chup thinks that many of you can't determine the difference between reality and anime. Think about that. That's Judge Chup's opinion of the public in the anime community. So, with all due respect to Judge Chup, great. But his job is not to heal the anime community. His job is to help us poor lost souls figure out reality for the first time. Like, that's not the role of the judge. The judge's job is apply the facts to the law. And when the judge doesn't apply the facts to the law, you have the option to either take the loss or you appeal it. And real quick, before the galaxy brain fucking morons of law Twitter out there, like the guy who is, I'm sure, live tweeting this stream right now, talk about the appeals, or wondering why Vic would appeal or why anybody would appeal ever after losing in court. That's the most disingenuous garbage they could possibly utter, and it just betrays their uninvested neutrality that they profess so furiously. Obviously, either side was going to appeal a negative decision in this case. They were going to. It wasn't going to go any other way for either side. The question was the nature of those appeals, what they would look like. If Vic won on all 17 counts and everybody thought that that total victory was in grasp and everything was great, that would be ludicrous. Now, the win condition for Vic is very different than the win condition for the defendants. And I want to talk about that a little bit too. This is going to be a little scattered of a stream because I've got days and days of thoughts about this. You know, going into all this, and I've been reading a lot and listening to things and watching things and trying to figure out kind of how things go. And then I've already mentioned how some of my focus is going to transition as this inevitably goes to a very drawn out and much quieter process. There will be filings. But like I said, there are limits on these filings, right? I believe in the Texas Court of Appeals, plaintiffs are limited to an overall 27,000 words. That's all you get. That's not a ton of words. 27,000 word limit is a lot. So we're not going to have multiple 40-page filings here from just the plaintiffs. The defendants are limited to even less, or the respondents, appellate and respondents, but they're limited to even less words in theirs because they're motion respondents basically. And so there's not going to be as many filings. They're not going to be as thick. And so there's going to be a bunch of lag period. And in there, I want to start talking about how to get Vic to work. Whether that's on the channel or not, that's something that I'm working on. I want you guys to know that. So I don't know how much of that will manifest in the channel because I just don't know. But I've been thinking about that. I've been trying to make some connections and do networking behind the scenes on this stuff. And before anybody accuses me of anything, no, Vic isn't paying me for this. I don't think Vic even knows that I'm doing this right now. I didn't ask his permission. I don't tend to do that, as we've seen over and over and over again. I think the guy was put in the wrong light by some bad people. I think a lot of people reacted. I think his lawsuit has given an opportunity for people to look at that evidence. And so I'm personally trying to work on some ways to help facilitate more bookings. Because I hate seeing this stuff happen. And I've met a bunch of great people, and I've met Vic, and I think with all those people involved, that there's just a genuine interest in getting him to different things. So I've been working a lot on that and thinking a lot on that over the past couple days. So I have a lot of thoughts, okay? And not as many thoughts as your average anime convention, but I have a good volume of them. That's a joke. But anyway, oh God, I tangented too long. Hold on. All right. But yes, the long and short is there's going to be it's going to be a completely different sort of ball game going into this appellate round. whatever you want to call it, round 2, round of appeals, road to appeals. I don't know. I don't know. But with that, there's a whole bunch of different content coming. And now I just need to kind of get back to where I was going. So first, I'm going to read these 2 super chats, and then we'll kind of get back into it and maybe pull up a document here in just a minute. Mega Emulator Man says, "Hey Nick, Vic was announced to be at a convention in Montgomery, Alabama. I'm from Oklahoma, so I'd have to take a flight out to go. I'm usually terrified taking trips this far on my own, but I'm willing to tough it out for Vic." Hey man, don't be scared to travel. Don't be scared to travel. You know, obviously within your comfort zone, but travel is great. Always good to go see a new place, even if it is Alabama. And that that's a throwback joke there. But even if it is Alabama, and go have fun at the convention. Go meet him. He really is an interesting person to talk to. Gothic says, "Funny how the usual grifters of Kick Vic raising their glass in celebration now are in full meltdown again. Now the real game is going to start." Yes. Oh, I was talking. Thank you, me, for delaying long enough for my dumb brain to catch back up. I was talking about the win conditions. The win conditions for Vic are different than the win conditions for Rial, Marquis, and Toye. Now, there's 2 separate things going on here, and this is something that, this is what pains me. When I read or listen or watch other people talking about this, when I do that, and I see these people out there who don't understand that there's 2 parts to this story. 2 parts to this story. Part 1 is the lawsuit. And the lawsuit, Ty clumsily got into this on the last stream he was here. He got a little flack for how it was said, but it's something that I've said for a long time. It's something that he's mentioned before. And so I want to kind of take a minute to clarify this. The lawsuit is critically important. You don't bring a lawsuit for any other reason than to get the court's redress for your grievances, right? You ask the court to remedy the wrong. All right? That is a critical thing, and any apparent downplaying of the lawsuit, let me just say, is apparent. The lawsuit is important. It's a meritorious lawsuit. The court has the tools to repair the damage done through money. That's how you repair the damage done to a reputation, is with money from the other person. Oh, and also with a ruling from the court saying the other person did bad. Okay? So the lawsuit is important. But the lawsuit is more important probably for the defendants than it is for Vic. And that's going to sound really weird. Okay? But hear me out. Stick with me on this for just a second. And in a way, it's not. But again, articulating this is frustrating. Vic winning the lawsuit really matters. Vic saving his reputation overall really, really matters. And may matter more than the lawsuit in the end. Now, the lawsuit is an integral cog of that, but it is just a cog. Vic's reputation will probably be wherever it's going to end up before the lawsuit is finished. And the result of the lawsuit will probably not have that much of an impact on it either way in the long run. In the short run, bringing the lawsuit was, in my opinion, critical to the restoration of reputation. Just was. You basically have a couple options. You can either try and get the court involved, or you can try and do it on your own, either through a PR firm, as some people have suggested, flat out going out and attacking your opponents. And it's been tried a whole bunch of different ways. Lawsuits are a way that has been tried. And I think personally that Vic has stayed off of social media largely. He's been pretty quiet about the lawsuit at conventions, generally speaking, and he's just kind of stayed back. And he's maintained over and over and over that this stuff that's being said about him is false. It's false. And the stuff that may not be false, and before I know someone out there who's brain dead is going to say, Nick admits stuff against Vic is true. Well, yeah, he has gay pants. Okay, that can't be falsified. They're the gayest pants. Those pants give Kevin Spacey's remainder of his life a run for their money in gayness. All right, we can't ignore how gay the pants are, and the truth will be told. But what I mean is, there are accusations against Vic that aren't really a problem for normal people, right? Like a hug in a convention line, honestly, is not a problem. The people making it out to be a problem need it to be a problem. And there's a big, big difference between I need something to be a problem and something is a problem. But the fact that someone will stand in a line for a couple hours and then watch everybody in front of them get a hug and then get a hug isn't a problem. And they have tons of opportunity to not get a hug. I think we're all on the same page there. And those opportunities, seriously, anything, even like a, hey, no thank you, or I don't want to be touched, or it's not like he's leaping over a table to give someone a hug. This is so ridiculous. I can't even. And the fact that there are morons out there latching onto this, they're aggressively hugging the idea, and maybe they should put down the universal remotes and go back inside and just go back to threatening to murder dogs or whatever they're doing. There are things that are out there that are being discussed. Well, for example, propositioning someone to have consensual sexual relations. There's nothing actually wrong with that. And at the at the point where our society decides that a person propositioning another person to consensual sexual relations is wrong, oh, thank God we can end the species. Just thank God at that point we can end it all. And it'll be quick. It won't last that long. At the point where asking another to engage in sexual relationships consensually ends, society ends really quickly. And we just get rid of it. But that being said, let me reel it back here. Proving that the defamatory statements are bad is limited to proving the defamatory statements are bad. That's it. Like, there will never be a lawsuit to say that hugs are okay. That will never, ever be out there. But what you can do is you can take the people who have sent the most damaging allegations, and that's a function of both what they said and who they are. Taking those most damaging allegations, and you can get everybody to look at that, and you can hopefully get a court to agree with you that those are defamatory. But really, shedding light on what this is all about. And let's not forget what this is all about. From Funimation's perspective, this is about the 3 stories. Jelly bean, consensual kiss in an office, and then asking twins for a little bit of booty. Okay? And I don't know of a man who has ever answered the question of 2 twins are ready for it, WYD, ? With I leave the room. I don't know of any guy out there who that's there. Like, it's a meme as old as time. Song older than Busta Rhymes. Okay? It just is. It's in Austin Powers. It's in all sorts of movies, both comedy and non. This is again, this is one of those things where people are trying to pretend that reality doesn't exist for the longest time. So, I mean, maybe all of the virtue signaling white knights out there, maybe they can pretend about it. But I have a hard time believing it. Okay, but anyway, so for Funimation, those are the three things. That's the investigation. They have had time after time after time to provide any different narrative to the investigation. They didn't do it. It's not in the discovery emails. It's not in their filings. It's not in the affidavits. What we do know is that in the discovery emails, Monica Rial's alleged sexual assault, and we'll get to that horse face in a minute. Her alleged sexual assault was not part of it. That was relayed to Funimation later, if I remember right, in those discovery emails. Correct me if I'm wrong, but that's not mentioned anywhere. And importantly, it wasn't mentioned to Vic during the investigation, and that is backed up by the emails from Tammy Denbo, exchange between Tammy Denbo and Vic. And it's backed up just quite simply in their affidavit. So that story was not incorporated in the investigation. Which, if you're gonna have someone investigated for being dangerous in the workplace, might be an important story to include when you're going to the investigator, when you're the person making the report. That just might be one of those things you add in there. If it happened. But it didn't happen. Or at least not that way. Did it, Monica? Didn't happen. Or at least not that way. One of those two. That's my conclusion. You guys will have to come to your own determinations about the veracity of that story. But I just have this feeling that maybe that story is a little more complicated. And maybe that story involves things like regret. Maybe that story involves things like jealousy from a little Soylent filled pustule. Maybe. I don't know. I don't have like the statements. I just have a whole lot of inferences. About maybe that story being a little different, which is maybe why you don't bring it up. Right? When you're trying to toast someone's career and get them removed from a company with allegations of sexual harassment or assault, and you decide not to bring up the one thing that would almost guarantee termination. But that's me. That's just my opinion. Okay, so Funimation, we now have the entire. Anyone with a penchant to look can find exactly what the story is. Exactly what that investigation entailed. They can do it. Will they? I don't know. Is it easy to find right now? I don't know. Maybe I need to help remedy that. I'm not sure. But that's that. For Monica, it's this story that's changed multiple times in material ways. A story where there was a witness, and the witness only to say, yeah, I don't remember anything like that. Nothing at all. Nope. And that's the witness that Monica mentioned, by the way. That's her witness. And you've noticed this, right? Monica has her initial stuff about Vic. She doesn't say anything. Then she has another story. Then she has another story. Suddenly he's pulling her hair every time they've ever met, ever. From the first time to the last time. He's out there just yanking her hair around like a caveman. For Jamie Marquis, it's this ridiculous one-off story, and then a whole bunch of quote feelings. And again, her story, we have to remember, starts with her initiating one of those non-consensual hugs. I mean, it doesn't say that she asked for his express consent. It even says this was a friendly environment where we often hugged each other, right? But a touch on the hair, that can't touch the hair. Now, granted, in her story, it's a grasp and a tug and a sexy whisper, right? Granted, that's her story. That's her story. No one else, of course, in the lobby of this building. There's no camera evidence. There's no eyewitnesses to this. Nothing. Just her words. So there's that. That's for Jamie Marquis. I mean, that's it. That's her statement against Vic. I mean, a statement that looks shockingly similar to both Monica's and Jesse Pridemore's things. I mean, again, maybe the case is that Vic is running around yanking hair. And of course, we have that video evidence of him doing that to Kara Edwards, or the photo evidence. The photo evidence of them reenacting a very particular scene taken by a friend who 10 years later decides that she was horrified by the thing that she posted in good fun on her Facebook. It's time to just remember where we are in all of this. Because this is... Hold on, I'm pulling something up here. But that's... What is my computer doing? Oh my goodness. There we go. That's Jamie Marquis. And of course for Ron Toye, well, even people sympathetic probably look at that and go, probably went a little off the deep end there, fam. Maybe you want to tone that down a bit. Wow. Alexis Rivera says, hey Nick, this is my first super chat ever. Just wanted to let you know that I've been here ever since the Vic thing started, but stayed for the quality content. I love your streams. Hope you can keep doing this. Stay safe. Hey, thanks, buddy. Budette? I don't know. Thank you very much. The Texan 83 says, can we get an F in chat for the cold, lonely bed Miss Whipple? If such a lady exists, must surely be used to sleeping in by now, while her husband pointlessly begs for attention from Senpai. Don't worry, buddy. We noticed you. That's too bad. At least someone did. So that's the contest here, right? That's what's at issue in the court case as far as the defamation is concerned. Did Funimation perform an investigation into sexual harassment that concluded that sexual harassment was that they found Vic guilty of sexual harassment? No. They've stated as much in their affidavits that they provided, that was not their intention to say. So, interestingly, if the court determines that that's the conclusion of that statement, then it must be defamatory. Because they said that that's not what it is. I guess. Very weird. Very weird approach. They should have just said, yeah, we meant to say it and we meant it. We meant it because it's true. Here's the thing. Here's the paper that says he did this stuff that we think he did. That's all they had to do to win. And they didn't. Can that get attached to the back of every plane and flown across the frickin' sky? All Funimation had to do was just say, yep, we meant it. Here's the report that says it. That's it. They win. No defamation. That's all they had to do. Look at how much time and money has been spent to not do that. To not just do that. They could redact the names. They could demand a gag order saying, look, our things are confidential. This can't come out. If it comes out, we need sanctions. They could do everything like that. Here, judge, here it is. Here's a report with redacted names to protect the victims of sexual violence. Here we go. It says he did it. There. We meant it. He's a scumbag. Get him out. Win, win, win. Case dismissed. Long time ago. Try appealing it. You're not going to win. They wouldn't have even filed it if that would have ever come out. Why didn't that come out? Think about it. It's so plainly obvious to anybody whose last name doesn't end in up. But anyway, that's all they had to do. That's it. Now, all Ron had to do is produce hundreds of women, right? Obviously, that wasn't going to happen. But notice, he's only produced Jamie and Monica and Kara Edwards with a really easy to debunk story. Who's he produced? Where the dozens to hundreds? All right. Anyway. So, them winning this thing ultimately ends up with kind of where they are. Kind of where they are. They've made these allegations. No one can confirm them. They're just out there in the ether. That's them winning. And that's a win for them, right? And hey, y'all out there in the industry working with these fine, upstanding ladies. And I include Ron Toye in that. You're next. If they win, you're next. Make no mistake, the moment that there's an opportunity, the moment that you cross them, you're next. So you better have your good boy pants on. And I know for some of you, that's trouble having your pants on, or at least your good boy pants on, around some of the ladies at Funimation. I know that's trouble for some of you who just retreat to your offices these days, who don't come out and don't talk to anybody because of how you've conducted your career at Funimation so far. I know that for some of you that might be a problem. But, that said, the moment you're vulnerable and it provides advantage, if they win, you're done. So enjoy that. Enjoy that. Blaine20 says, most Kick Vic have run blockchains. The only ones blabbering are the mentally ill, Jenny, and the incels who never got any for their efforts, BT. I don't know who BT is. Or Jenny, frankly. Some law twats are still running with bad info. No T. Greg lied about, such as your license expiring, that Vic started an LLC to hide his assets. Well, there you go. That being said, you next. Stab. That's enjoy that world. If they win, enjoy the world that builds. Asset Obfuscation LLC is a fantastic business name. Okay. All right. Vic winning counters these statements by saying that they couldn't prove that they're true, right? And presumably Vic gets money of some amount. Who knows how much in the end? Depends on who the defendants end up being, right? But he gets a piece of paper that says, see, the things they said about me, the court says that they didn't do a good enough job saying them. That's Vic's court win. And again, I don't want to downplay the importance of that win. It is very important. But that's not victory in the long run. Like, that alone is not victory. And you can ask people who have been defamed if the court victory is enough to undo. Even with the money, is that enough to undo the damage that's done to you? In the short term, maybe. Maybe it's good. Maybe the money's good. Depends on the money, right? Sargon's the money. It depends on how much you get. But in the long run, that stuff's out there. Hangs around. It will always be there. You're always going to get a question. Hey, aren't you that guy that this? Well, listen, I sued those people and I won. They're like, oh, okay. That's always going to be there. But bringing the suit, getting people interested, getting people to see it, getting people who will buy tickets to a convention to know, I didn't do this. I didn't do these things. People are lying about me. That's the ultimate longer-term win condition. And the fact that there are so many attorneys out there who don't see how these two things go hand in hand is flatly embarrassing to the profession. And shame on you all for either not seeing it or lying about seeing it. That's all. That's it. But anyway, now that, now that the public figure question is in the hands of the appeals court, now that we're past all that, I hope Vic will speak up soon. I really do. What about you guys? I think Vic's voice needs to be heard. There have been a lot of people defending Vic, myself included. Right? Nick Rekieta admits to defending Vic in court. Myself included in the social media defense of Vic. The one person that I want to hear defend himself is Vic. Personally, that's me. I think you guys are in the same boat. But I think it would mean just an absolute ton for Vic to come out and publicly say, I tried to do this. I tried to just clear my name. These people have persisted in defaming me, in lying about me for 8 straight months. Despite me barely saying anything to them, trying to go away and just clear my reputation through the proper process. Well, I'm tired of it. They're lying about me, and they're trying to ruin my name. And all of it's fake. All of it's false. And it's pathetic. That's what I want Vic to come out and say. And I guess now, you know, it probably doesn't impact that whole public figure doctrine or anything like that. That's all in the past. It's all in the past. But we'll see. That's, you know, that's up to him. That's what I want to see. That's what I want to see. Okay. I'm going to pull up the document in just a second, but I noticed a name in the chat who's here, and this guy has sent 3 knives. And calling one of them a knife is generous, or not generous. It's underselling what it is. And I am trying to find a way. Look, this guy is great. He wanted to contribute in a way to the GoFundMe. And so he brought his talent to it. And I'm trying to find a way to sell these knives to you fine folk or whoever's interested in supporting Vic, and then contribute the proceeds to the GoFundMe. That's what I'm trying to do. And that's going to come soon, but I want to show you these guys real quick. All right. Now, he sent me the names of this stuff, and forgive me, Ken, for not remembering the names. These are handcrafted, the knives and the sheaths. So here is here's the first one. This is a small one, right? This is blades, what, 3.5, 4 inches, 3.5? Oh. Ladies, you're the experts. Here's the knife. The handle work is beautiful. Full tang blades. These are durable. They're not durable. They're sturdy, right? These are not little flimsy stamped things. These are forged. Handmade leather sheath. Very cool that it goes into. 3 3/4 inches. Thank you, Ken. Easily a 10-inch blade. Thanks, short round. So that's the first one. That's the first one. The second one is similar, larger. This is about a 6.5, something like that. Ken, you can probably remind me. Again, same level of craftsmanship, full tang blade, nice handle work here. Sits in the hand rather nicely. And yeah, they're Klingon style knives. They're, you know, here's the yeah, sheath for that. The next one's a little different. The next one's got so just shy of 7 inches. Next one is a handmade wooden sheath with leather sort of bracing, I guess. I'm gonna show you the sheath for. Well, I gotta show you the knife first because it's comically large. Here, look at this thing. So here is this. This is a large thing. And it's sharp on both sides. Comes to a nice point here. But yeah, this is cool. Again, full tank. Check out the. I don't know if you can see the handle work here. It's very cool pattern. It looks even cooler kind of in person, but I can't show you. But anyway, yeah. And here's the I'll put it in the sheath here. So here's the sheath. It's like I said, it's wood. It's beautiful. Great, really fantastic job on these, Ken. These are awesome. So I'm going to, when I put up the auction, and I'll announce it, when I put that up, I'll have the actual descriptions he sent me. They're very much Klingon inspired. They're Klingon inspired designs. So if you like, if you're into Star Trek, right? As I know many of you may be, you may have interest in 1, 2, or 3 of these things. Yeah. So there you go. These are monstrous cutlery, and yeah, I can't wait to see what they'll bring in. Hopefully, you guys will be interested in them. What are the stats on that weapon? It's at least a +3. Okay. So these are the those are the knives. I wanted to bring those up because I just got the big one in the mail the other day, and I think this is the first stream I've done that's Vic related since that. So I wanted to show those to you guys. But it's a damn sword. Yeah, actually, I've got to look into the laws on that and make sure, you know, that we can legally transfer that to whatever state the buyer's in. Just to be clear, because you may have to have like a carry permit for it in some states. I think actually to leave my house with that knife in Minnesota, I would need a carry permit. Because we don't have like open carry and then a concealed carry permit. It's a carry permit for all weapons, and that may just be a weapon, but it is very cool around the house, especially. So you shouldn't have to have one to be around the house, but we'll look into that. DOG Beerus says, Nick, you have some nerve calling Vic's pants gay when you wear those gay shorts. Hey, my shorts are not gay; they're dad shorts. Also, which is inherently the opposite. Also, if the defendants win the lawsuit, doesn't it open the door for people to slander him since they can just hide behind a TCPA? The door has been open for people to slander Vic since this all started. Right? That's why these are the target. They're the damaging tweets. They're the ones, tweets, statements, they're the ones that give everybody else the ammunition to say what they do. That's why. So, will the door be open? Really no more than it is now. You can't sue everybody all the time. Even if you win, you can't do it. You run out of money, you run out of time. Okay. So that said, let's get into this document. Right? Oh, where did we go? Have I ever listened to Vic's music? No. Not knowingly. Not willingly. Except at one time at a convention, Vic invited me to his room. When I got there, he put his hand on my shoulder, and he took off his belt, and he belted me to the chair. He made me listen to Christian music for 2 hours that he wrote. Oh my God. Okay, sorry. That was probably a bit strong. Judges. Order. They meant we could defame Ronica if they win. Oh, well, yeah. Okay. Here we go. Let's see if I did this right. Nope. Oh, God. Give me a second. I know what happened. I know what happened. And I'm gonna fix it. I promise. What do we got here? This one. This is what I want. Nope. 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 This one? Oh, baby. I might have done this right. Don't do me wrong. There we go. Boom. Okay. Whew. Oh, hey, do you guys want a quick update on the West Nile Best Nile? I found out what happened to it. The West Nile Best Nile mug. This is great. In the description, the artist, my artist, wrote up the description of it and said the colors were inspired by One Punch Man. Okay? The colors were inspired by One Punch Man. That was apparently a grievous infraction upon the trademark of One Punch Man. Now, One Punch Man or the owners or whoever did not actually file anything. They didn't send, they didn't do a notification to take down. It must have been the algorithm of Teespring catching One Punch Man in the description or something like that. But because of that, colors inspired by One Punch Man, or color scheme or whatever by One Punch Man, boom. That was the takedown. So it'll be back up with a new description really soon. Just absolutely ridiculous. But you know, there you go. Like I said, they didn't file anything. There was no notification that I received for me to appeal. I just got it was an automated takedown. I escalated it to the IP department at Teespring, and they said, oh, it was because you mentioned One Punch Man, our thing picked it up, and there's an open trademark involving One Punch Man, so there you go. So it's like, oh. I mean, I didn't think that people would be confused that that was being offered by the One Punch Man brand, but all right. All right. So, but to be clear, Viz Media, whoever owns the trademark to One Punch Man, did not issue a takedown on this. It's just Teespring's internal system, and the easiest way is just to upload the campaign again without the words One Punch Man in there. Or maybe I'll specifically put them in there at like in an acrostic or something, just to be a dick. But there's nothing wrong with it. So that'll be back up soon. There's nothing wrong with the art or the design of the mug itself, which I thought they were trying to pull that off, but they weren't. So that said, West Nile Best Nile will be back up very soon. I've asked my guy to put it back up. So, yeah, let's take a look at this. So here's the order from Judge Chup again. I guess we got to go through. There's a whole lot to this. There's a whole lot of appealable stuff. I've kind of talked about it in a stream before. It's a little less focused than this. And I don't want to go through like all of the stuff. If we go through all of this, yeah. So he does find that the response to the defendant's TCPA motion to dismiss is timely filed. So that's in the record for sure. He says that they withdrew the affidavits. Therefore, the court did not consider the withdrawn affidavits. I've mentioned before, but this is going to be a problem for Chup's analysis. If I say, I might shorthand say this is a problem for Chup. It's not a problem for Chup. Nothing's going to happen to Judge Chup other than potentially he gets overturned. His decision gets overturned on appeal, and that's that. Okay? That doesn't, so if I say that, it's just a shorthand for this is a problem with Chup's opinion. This is a problem for Chup, okay? The court did not consider the withdrawn affidavits. Well, the court did consider the withdrawn affidavits. In court, he did. And then I'm pretty sure later he decided he couldn't possibly have considered them because if he did, he couldn't dismiss the TI against Ron. He just can't dismiss the TI against Ron if Slaytosh's affidavit is admitted. Can't do it. Can't do it. It's a slam dunk to the case. If that affidavit's admitted, slam dunk. So the court says they did not consider it. Plaintiff additionally filed second amended petition on September 3rd, 2019. Oh yeah, but they'll point out that at the hearing, they were able to rely on these affidavits and then to make their argument, and then the court said that they couldn't after the fact. The reason this matters is because if at the hearing the judge had said, I'm going to strike the affidavits, they could object to striking the affidavits. Or more appropriately, they could object to striking of the unsworn declarations. Now, in that hearing, Ty asked for a trial amendment to use the unsworn declarations, and rather than rule on that trial amendment motion that Ty made in court, judge said, I think I'm going to consider these. I have to. I've already read them. I'm probably already considering them. So again, Chup has done this throughout the case. Throughout the entire case, he has done this thing where he avoids actually issuing a ruling, which might be kind of clever to get someone to do something that you want them to do, or to not have to issue a written opinion on it. That's fine. But it makes it really murky when you're not allowed to object because there's no ruling. I'm going to strike the petition. Objection, Your Honor. You can't strike the petition, or the grounds for striking it are improper. We're objecting to this and appealing it and preserving it for the record on appeal. He doesn't even afford them that courtesy to allow them to preserve the objection on appeal. Doesn't do it. And if you don't strike the second amended petition, you can't just decide to use the first amended petition. But he just said here, accordingly, the court did not consider evidence submitted after the agreed upon deadline in the Rule 11 agreement, with the exception of plaintiff's response to the thing which was deemed timely filed by this order. This doesn't work. For one, it's also a violation of the Rule 11 agreement. Do I need to pull up that Rule 11 agreement? I've got it somewhere here. Just a second. Let's see. Here's the Rule 11 agreement. Let's pull it up. Truth be told, I don't remember exactly the language, so it'll be good to refresh on it. But it's good that we can do this. All right. Let's read this Rule 11 agreement, because this is what Chup is going off of. And this is what the defendants argued in court. That's important too. Under Rule 11 of the Texas Rules of Civil Procedure, this will confirm our agreement regarding scheduling matters related to defendant's motion to dismiss under the Texas Citizens Participation Act. Parties agree to the following. Plaintiff will file his responses to the TCPA motions and any objections/motions to strike on or before August 30th, 2019. That was done. Defendants will file their replies and any evidentiary objections in support of their TCPA motions and any objections/motions to strike on or before September 3rd, 2019. Hearings for defendant's motion to dismiss and any party's objections, motions to strike are set for September 6th at 10 a.m. Plaintiff agreed that the 60-day hearing deadline for Funimation is extended to September 6th. Hearing on plaintiff's motion to strike that is currently set for August 8th has been moved to September 6th as stated above. That's it. This is it. So what the judge has ruled, what the defendants argue and the judge determined, is that the court would not consider evidence submitted after the agreed upon deadline in the Rule 11 agreement with the exception of the response, blah, 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 blah. One, where is evidence mentioned? I don't see the word evidence in the document. Just responses to the TCPA motions and any objections. There's nothing about evidence in here, and there's nothing about amended pleadings. So, this again is a problem for Chup. So the real question is, here we go. Now, he doesn't close his quote here because Chup appears to be very sloppy in his legal writing, especially in this document. He opens the quote here. It should close here after the footnote, but it doesn't. Or I guess technically it should probably close before the footnote, but it doesn't. Nothing in the TCPA statute. Now, importantly, this paper that he cites to, I didn't mention this before because I hadn't read through the paper. This paper is about the new TCPA law, the new one that does not apply to this case. So the paper is off point in that way specifically. And this line is not actually supported by case law in the paper, not adequate case law. This is a law review article. This is not controlling authority. This is secondary persuasive authority. You can use it to attempt to sway an opinion. You can't use it to bind the court in this way, and the court can't use it to bind itself. But they don't have a better thing. So what Chup is faced with here is, how do I violate Rule 63 of Texas Rules of Civil Procedure and justify it? To put it bluntly, that's what Judge Chup is doing here. He's got to figure out how to justify violating a rule of civil procedure. And there's no way around that. The Rule 11 agreement doesn't cover it. And no other rule would preclude anything about what happened except for possibly Rule 63. And if you don't remember what Rule 63 says, I'll give you the summary. It says you can amend a pleading at any time without leave of the court except for within 7 days of a trial. What Judge Chup could have done, he didn't do. He tries to do it with this line, the second part of this line, possibly a violation of the Texas Rules of Civil Procedure. They're talking about Rule 63. He tries to infer it there without making the decision because, again, Judge Chup seems like a coward who can't make a ruling on these things. Why? I mean, probably because his rulings on these things are wrong. That's one good reason why he doesn't seem to want to make the ruling. But, or I shouldn't even say wrong. I'm being uncharitable. It's not that he's wrong. It's just that if he's right, he's not supported by case law or the plain language of the rule. That's it. If he's right, what he would have to do is try and liken the TCPA hearing to a summary judgment hearing. And there are problems with that. And I believe there's actually a split in the court, in the authority on the appeals court, where it says that in some districts, a TCPA hearing is like a summary judgment hearing, and in others, and I think Tarrant County is one of those, which is maybe why he did this. But I believe in Tarrant County, they say a TCPA is not like a summary judgment hearing because there is no evidence being admitted at the summary judgment or at the TCPA hearing. There are various other things. It's only dispositive in, for one party. Long story short, there are differences. Now, the courts may ultimately determine that they're not different enough and that it is a trial under Rule 63. And Judge Chupp could have done that, but he didn't do that. And that's telling. But again, it's speaking to the unwillingness of Chupp to actually make rulings. I don't know if he's afraid of getting appealed or what. It doesn't make sense. He had to know this is going to appeals. He mentioned it. Flat out mentioned it. Okay, so let's move past this. I gotta get past this because I'm gonna go nuts here. Okay. So now we get to the cause of action. So this is interesting. The court finds that defendants have shown by a preponderance of the evidence that all causes of action against all defendants asserted by Plaintiff Mignogna are based on or relate to or in response to the defendant's right of free speech, right to petition, or the right to association under the TCPA. Now, I am told that Vic is appealing all 17 causes of action. I am not told whether or not he's appealing this ruling, this preponderance of the evidence ruling that the TCPA applies, but I have to guess they're going to at least put a section in there on it to get the Court of Appeals to determine if it does apply. I've said for a long time, I think the TCPA probably applies to all of these causes of action. I've heard some interesting thoughts that it might not apply to the TI and it might not apply to the civil conspiracy. Was it civil conspiracy or no. Respondeat superior. But I haven't seen like a fully fleshed out argument on it. I've just heard some thoughts that maybe it doesn't apply. Whether or not Vic's team thinks that, I don't know. But I was not specifically talked to about whether or not they would challenge the applicability of the TCPA itself. We'll have to wait and see on that one. We'll have to wait and see. But again, this is one of those, there wasn't a lot that I remember from the hearing actually arguing this. Now, for a preponderance of the evidence standard, that offers both sides the opportunity to bring in evidence and then have a hearing on the evidence. Chupp did allow the defendants to make the case that the TCPA applies. I don't remember if he gave the plaintiff's attorney much opportunity to rebut that, but I'm going to defer and say that this probably is okay. So I'm going to ignore it. Okay? Okay. Additionally, the court finds that defendants have shown by a preponderance of the evidence that the communication related to plaintiff's causes of action relate to a public concern, and the communications involve allegations of conduct by plaintiff that relate to health and safety, environmental, economic, or community well-being. Maybe. Again, this is one of those where I've got to go back through the hearing transcript, and I may or may not do a show on at least portions of the hearing transcript as they relate to appeals. When the appeal documents are filed, I probably will have to cover part of them, but there are so many people out there saltily suggesting that I won't do it because I'm somehow afraid of what happened at the TCPA hearing. Even though everybody can actually go read it and tons of people have talked about it, that I'm afraid to read what's in the text, that I won't cover it. So I tend to not do things that people definitely want me to do. That's a rule, especially people who don't pay me and are giant weepy vaginas online. I'm just not really interested in giving in to their very considered demands. and there's someone you can ask about how well it goes to persistently demand to come on my show if you want evidence of how that works out. But I will probably at some point cover the TCPA hearings, at least in relevant part to what's in the appeals. For now, I'm going to default to accepting that they did this adequately. I just don't remember the specific arguments that the plaintiff was either allowed to make or did make in court to rebut this. So but I don't want to say that this is wrong. I think this is probably correct. Like I said, I think the TCPA applies. So here we go. This is the defamation section, and this is the closest thing Chup does to putting any facts into the law. He pulls this article or this part out of his petition, which he doesn't cite which petition it is. So maybe it's the original petition, which he can't actually cite to because it doesn't exist. It's replaced effectively as a matter of law by the first amended petition, which would be also replaced subsequently by the second amended petition, but it doesn't say which one it is, although I think, to be fair, it's a copy paste in all three of this portion. But I don't know. He doesn't actually cite to it. Why doesn't he cite to it? He had the document up. He had to have the document up to put this in there. Okay, so in addition to plaintiff's assertions, defendants provided specific evidence in their motion replies that are before this court, and they have argued that plaintiff is a public figure as contemplated by Texas defamation law. I don't remember this argument taking place in the courthouse, and I don't remember a counter argument being available to the plaintiff on this issue. What I remember is Judge Chup saying, well, I think I agree with you that he's a public figure, and didn't hear the arguments, and specifically didn't hear the arguments of the plaintiff. He said, I don't usually have this many people show up to a courtroom, so he must be, or whatever, something along those lines. That is not actually allowing the parties to suss out and make arguments about what the facts and law, because public figure doctrine is a mixed question of fact and law. There are facts that need to be presented, and then it's ruled on as a matter of law by the judge. The facts came from one side. The arguments over the application of law came from one side and not the other. I don't know if that counts. The judge doesn't provide his reasoning. This court must recognize and apply the reasoning of the Second Court of Appeals in Lane versus Ferris. And now, again, Lane versus Ferris is distinguishable from Vic for several reasons, which we won't get into. He just says there's similar facts and circumstances. But either way, let's just take, again, for example, that Vic is a public figure. For now, to avoid too much discussion on this topic. But the reason I even read through it in the first place is preponderance of the evidence. First of all, I don't know that it is a preponderance of the evidence standard that determines public figure status. I think it's a matter of law. The judge rules on it as a matter of law. Now, he may base it on a preponderance of the evidence. I'm not sure if that's... I got to look into it. But either way, I don't think we have a legitimate question of whether or not the evidence... No, we do have a legitimate question of whether or not the evidence is properly considered before the court in this ruling. And especially since he doesn't lay out the evidence other than this one thing from the petition. And now he doesn't say that... He could say that this is sufficient to establish public figure as a matter of law. Right there. He could do that, but they don't. And the reason they don't is because it's a more complicated question. It's a question about whether or not he injected himself into the public discussion. Now, the defense has argued that he has. The plaintiff didn't get much opportunity to argue that he hasn't. So anyway, this is another one of those areas. I assume they'll they'll appeal this part of the ruling. Certainly, they'll appeal it and try and distinguish Lane versus Ferris. If they, I shouldn't say certainly they'll appeal it. Certainly, they'll try and distinguish Lane v. Ferris if they do appeal it. But we'll see. We'll see. Anyway, additionally, the court finds that plaintiff has failed to establish by clear and specific evidence a prima facie case for each element of his defamation cause of action against all defendants. This is where we really have to begin. This is where we really have to begin, okay? And you're right, Awig. He did not distinguish between limited and general public figures. And there's a reason he didn't. One, because there's almost no way that Vic is a general purpose public figure. And two, there's almost no way that Vic is a limited purpose public figure. But Vic, if you combine limited purpose public figure requirements for the public aspect of it and general purpose public figure for the hard to defame aspect of it, well, then it's just fine. Then he did a good job combining those two standards. Perfect. But let's go with this. Failed to establish by clear and specific evidence a prima facie case for each element of his defamation cause of action against all defendants. Okay. Can we pull up the elements? I want to say these correctly. Okay. All right. All right. Okay. Okay. So the elements of defamation, and we're going to do the public figure defamation. Let's go with the hardest standard here. So remember, we just have to show a prima facie case for it. And we're going to go person by person, and we'll see if we can find it in the record. Because that's the trick, right? Is it in the record? Is it in the record? And where in the record is it? Let's look for it. Okay. The elements of defamation are: a statement was made by the defendant to a third party or a number of third parties, but not just privately to the plaintiff. Like if I come to you and I say, you rape children, and you say, that's defamatory, bro. It isn't, unless someone else is around me to hear it. But if I'm just making the statement, me to you in private, and I know you have no duty to disclose that to someone else, that's a whole weird limited aspect, a limited amount of cases. But just generally speaking, we walk up, I say, you did this thing, and you say that's defamatory. It's not, unless I tell it to a third party, someone other than you, about you, okay? So a statement made by the defendant to a third party that is defamatory concerning the plaintiff. And, sorry, the defendant acted with either actual malice if the plaintiff is a public figure, or negligence if the plaintiff is a private figure. We're going to be concerned with actual malice, okay? Actual malice. Let's start with Funimation. Now, defamatory in the legal context, the legal definition of defamatory is, the definition of defamatory is anything that would tend to damage someone's reputation. That's defamatory. Legally defamatory means it has to be a statement of fact that is false. Okay? That's how we do that. So we're going to go with legally defamatory. So these have to be factual statements, not opinions, that are false about the plaintiff. Let's start with Funimation's. Can we find Funimation's tweet anywhere? Here we go. We've got the, let's pull up the amended complaint. Where you at? Oh my God. Here we go. First amended petition. Let's just do a skim through and see if we happen to have that tweet by Funimation. Oh, there it is. Okay. So this is the first amended petition. Importantly, this is the one that the court has said they're working on. And that's what I'm going to attempt to do here. That's what I'm going to attempt to do here. Do we have the petition, or do we have in evidence available that the lower court considered? Not just that we could get the appeals court to consider. Oh man, I think one of my mustache hairs curled up into my nose. Do we have just what the lower court says it considered? All right, here's Funimation's tweets. So, did Funimation make a statement to a third party? Twitter, by the way, is posting publicly on Twitter is a third party. Period. 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 So that definitely happened. Now, remember what we're talking about. This section here. Failed to establish by clear and specific evidence a prima facie case for each element of his defamation cause of action against all defendants. So we already know in the petition that the court considered, we have a statement made to a third party, which is defamatory, which means, and there's all sorts of stuff about how in a TCPA motion, all deference goes to the non-moving party, which is Vic. So they say, update on the Vic Mignogna situation. This is on February 11th. Everybody's talking about the Vic Mignogna situation. Following an investigation, Funimation recast Vic Mignogna and Morose Mononoke in Season 2. Will not be engaging Mignogna in future productions. Part of our core mission is to celebrate the diversity of the anime community and share our love for this genre and its positive impact on all. We do not condone any kind of harassment or threatening behavior being directed at anyone. So there you go. So that's their statement. It's included in the petition. It is a statement made to a third party. It is claimed to be defamatory. That would be the prima facie showing, by the way. This is defamatory because this says that Vic was found that their investigation concluded that Vic was guilty of some sort of threatening or harassing behavior. Harassment or threatening behavior, right? Sexual or otherwise. That's what's inferred by this statement by the people reading it. It's in the context of the situation where he's being called a pedophile, a creeper, a sex offender, all of those things. So they're saying that they did an investigation on that situation and then decided not to work with him. Okay. So claim is that that's false. Next claim is, was it made with actual malice? Well, here's the deal. The company who conducted the investigation knows what's in the investigative report. Actually, they've maintained that they're pretty much the only people that know. They're the ones who know what's in the report. So, if what's in the report is not them finding Vic guilty of some sort of harassment or threatening behavior, then it is actual malice. Then they're acting with knowledge of the falsity of their statement. Because they're the only people who can know. Well, them and Vic, right? Vic knows it's in the investigation. Funimation knows it's in the investigation. But they have to act with knowledge of the falsity if they're talking about their own decision-making process. So, do we have a prima facie case of defamation against Funimation? Yes. I don't know how else to say it. We know that they said it. We know that they said it to somebody else. The allegation is that it's false. And that's a prima facie showing, by the way. That's a false claim. And in fact, they've argued both in court and through affidavit that they didn't intend that meaning. That was not the intent of the statement. I shouldn't say they didn't intend it. The statement was not meant to imply this, they say. These are factual statements. We weren't trying to imply that. Well, that's self-serving and lovely and all, but they're flat out saying that it doesn't say what other people read. Like this one. Like this random person here, Monica Rial, saying, this is a response to this tweet. There were multiple investigations with testimony, proof, evidence. Companies don't cut tie without those things. However, that information is classified. I am one of dozens of men and women who participated. Stop harassing me. By the way, that's dozens of men and women. That's a false statement of fact too. But, you know, we're getting ahead of ourselves. Do we have false statements of fact about Vic Mignogna? Yes, yes, yes. And implied defamation is a thing. The long and short is the gist of the statement. Is the gist of the statement one that tends to cast the light worse on the plaintiff? Yes. Yes. And if it's false, false. Yes. So, does the gist of this statement, and this is the publication, right? This would be the argument under Texas law, is that these three tweets together are the single publication, and that the overall gist of this publication, by omission of facts, like we did the update, we didn't find him guilty of sexual harassment or assault or threatening behavior, but we're firing him anyway. There you go. Non-defamatory. Non-defamatory. Why didn't they do that? Oh, because people would have chewed them to death, including the person with the biggest teeth of all, Monica Rial. She would put those horse munchers down right into Funimation's backside and tear them apart if they would have said that. And they know it. But so would everybody else, but for different reasons. Next question. Did Jamie Marquis do it? This is a tougher question. So do we have Jamie Marquis' main tweet in here? We don't have Marquis' tweet in here. Do we have any tweets by Marquis in here? We have the head and balls one from Jamie Marquis. We have this right here, but there's no evidence, right? Okay. So this looks like a problem. This looks like a problem. Except, is it a problem? That's where we need to go to the other things that the court considers as evidence. And if you think that it's not in here, I've got news for you. Just a minute. Just a minute. Okay, here we go. I think it's right here. For court summons episode doesn't matter. So here is Jamie Marquis' motion to dismiss. What do we have in here? It'd be really interesting if we had Jamie Marquis' hair-pulling tweet in here somewhere. Oh, wait a minute. Here it is. It's right here. It's in her filing. So I guess that's a problem, right? I stand with the victims. My experience is minor in comparison to many others. However, having realized this wasn't an isolated incident, I felt compelled to share. And then, brah, there we go. And to make matters worse, Sam asked Vic about this in the deposition of Vic Mignogna, and they included it. Right. Oh, look, they went ahead and included these tweets as well. Right here. Here we go. Deposition of Vic. Man, they're still blasted about that GoFundMe. Let's see what we got. Oh, God. Oh, here we go. Here we go. Johnson asks him specifically about it in his deposition and then goes ahead and puts those statements in the deposition. So even if we don't have the tweet, we have plenty of evidence that she made a statement. Remember, this is what the evidence has to show. Did she make a statement? Yes. To a third party. The statement is talked about in the deposition, and it's specifically in the tweet up here earlier. Right here. To a third party. Yes, she made it on Twitter. Is it defamatory? Okay, when you read this tweet, when you read this statement, does this make Vic look better or worse? Obviously worse. It says that he grabbed her hair, pulled her in, although maybe that looks better because he would have to have massive amounts of bicep and oblique strength to haul that locomotive train in close. That he whispered something sexual into her ear. All of those things that he flatly denies doing. The only thing he admits to doing is maybe touching her hair. At all. At all. But, so if you read this, does it cast him in a negative light? Yes. Defamatory. There you go. There you go. Vic is asserted as false. He gets the deference. Says these things didn't happen. The judge actually addressed this in court. I got to point that out. The judge addressed to Sam Johnson that those were fact statements in there that could be false and therefore defamatory. But, and then, did she do it with actual malice? Well, this is Vanderlinden versus Khan. Who else saw the incident? No one. It's just he said, she said. Those are the only two people on earth who know it's true. Malice. That's the argument. Whether or not the court accepts it, it depends on whether or not they accept their own ruling in Vanderlinden versus Khan. In which, in Vanderlinden versus Khan, the question was, did he say these things to you? He says he didn't say these things to you. Therefore, that's enough to pass TCPA. Because you two know if he said them or not. He says he did not. He gets a deference because he's the plaintiff and the non-moving party. If he did not, does that cast him in a negative light? Yes. Defamatory, done. That's how the argument goes. That's likely how the argument on this will go. She can point to no one else who knows the truth of this encounter or who even witnessed it or remembers it. No one else. So it's just her and Vic. That's it. Vic says it didn't happen. She says it did. If it didn't happen, it's defamatory. And if it didn't happen, it's defamatory and she said it maliciously. A lie about it. That's enough for TCPA. Now, they may get to a deposition and she gives a heartfelt thing about how she desperately remembers it and recounts it all his ways and blah, blah, blah. And a jury decides differently. That's a different question months down the road. For the purpose of TCPA, all the deference is supposed to go to Vic. So the question is, did she make a statement? Yes. To a third party? Yes. Concerning the plaintiff? Yes. Was it false and defamatory? Yes. Was it made with actual malice? Yes. Under the standard of Vanderlinden versus Kahn? Yes. Done. Jamie should be in here on defamation. It's in the suit. It's filed in the record. The judge talked to Sam Johnson about it. It should be included in here, and that it's not is just a tribute to Judge Chupp's special needs status. Actually, that was rude to special needs people. Monica Rial. We have the exact same issue, right? We have the deposition of Monica Rial. I'm not going to pull all of that up, although it may just be... Well, here we go. Actually, let me go ahead and pull it up for you. This is Monica and Ron's filing. It is 529 pages. Right? This is the one with all of the garbage in it. Here we go. Great. Great. Lots of exhibits. Lots of exhibits. Jamie Marquis stuff is in here. Let me find Well, hold on one second. I want to point out that we do have... What was it? We have Monica Rial here. Multiple investigations. That's defamatory, flat out. Just so we're clear, he's the legal definition of harassment governed by state laws, but is generally defined as a course of conduct which annoys, threatens, intimidates, alarms, or puts a person in fear of safety. She's flat out saying that he is the... Now, I know she has said that she was saying, here's the legal definition of harassment. But that's a matter for the jury to determine. She's saying he's a legal definition of harassment, that he is a crime. Here's more. Investigations were incredibly thorough. Each person was interviewed, the evidence weighed, and a decision made. The company has to look out for the safety of their employees, blah, blah, blah. I don't have the exhibits that were attached to this for some reason. So we'll look here in their TCPA. Let's see. See if I can find. Here we go. Here. They went ahead and put their interrogatory responses. Why did they put their interrogatory responses in the document here? Oh, yeah. They went ahead and did it. So here we go. Here's Monica's interrogatory response, in which she tells a story. I mean, the other thing that that Ty and company did is they included the deposition transcripts for all of the depositions in their filing, which is what pushed it to over 1,000 pages. And in that deposition transcript, we have the Monica telling the story, right? That's in the deposition. You can go watch the video. But here is her just telling the story. Plaintiff grabbed and kissed defendant without defendant's consent on Sunday, November 4th, 2007. While plaintiff and defendant were both attending a ZoomiCon in Oklahoma City, Oklahoma. So this is not specifically the evidence in regards to, it's not the tweet, but it's there. Identify the instance in the mid-2000s, including the name of the convention when plaintiff grabbed you and kissed you in his hotel room, as you alleged in the tweet you posted to Realisms on February 19th, 2019. So there you go. So this tweet is right here. There's evidence that this happened. Not only that, she's admitting to making the tweet, acknowledging the existence of the tweet, and answering under oath that this is what happened next. After several other guests had left Oklahoma City, Stan Dolan, one of the convention chairmen, invited plaintiff and defendant to dinner. Plaintiff requested that defendant accompany plaintiff to plaintiff's hotel room to view plaintiff's fan film called Full Metal Fantasy. Mr. Dolan stated he would collect us both for dinner from plaintiff's hotel room. Plaintiff played the video as promised while defendant stood to watch the video, but soon, plaintiff soon grabbed defendant by the upper arms and began aggressively kissing defendant. Defendant attempted to resist, but plaintiff physically restrained defendant and pushed defendant backward towards the bed. Plaintiff climbed on top of defendant and held her down as he continued to aggressively kiss defendant. Plaintiff continued in this fashion for several minutes, despite defendant's fear and shock, until Mr. Dolan knocked on plaintiff's hotel room door. Plaintiff left defendant on the bed and hurriedly answered the door. Mr. Dolan inquired whether defendant was okay, clearly noticing distress. Defendant, however, was too shocked and afraid to admit what had occurred. Following dinner, plaintiff forced defendant to speak with plaintiff's longtime fiancé on the telephone, and plaintiff spoke with his fiancé as if nothing had happened. Okay, so this is, again, some evidence. Now, never mind that this story is different than what she told at deposition, right? And I could... let me see if I can find that real quick. Oh my. Let me see if I can pull up the transcript. I'm trying to remember. Where I've got it. Okay, hold on. Would have been back here. Well, I could just do this one. Oh my. Here we go. Is this the one? I think this is it. Hold on. Wait, that's not the one. Where? Is this it? Yeah, here we go. Okay, 1 second. Here. All 1,100 pages of this nonsense. Let me pull up. I want to see if we've got it. We should have it in the transcript here. Oh, come on. This might take me infinity time to find. Because for some reason it's not... let's see. Oh, how annoying. I'm having trouble searching through this here. Here we go. Here we go. At AzumiCon 2007. Okay. Here we go. Here we go. Here's the story. Sorry. I want to point out though, like, because again, I want to point to this stuff in the documents. In the documents. Is there evidence? It's what they call a dead dog, which is a little get together they do after the convention to kind of wrap everything up with staffers and but actually, you know what? I guess this doesn't really matter because we've got the tweet mentioned in the interrogatories, and that tweet is evidence that she made the statement that is false. But I just want to point out the thing. And Stan giving you a time when you were going to go to dinner. I don't recall whether he gave a specific time. I know he did say, I'll go by the room and get you and we're on our way. How long were you in Vic's room? Oh, I don't know. How did Stan know to knock on the door of Vic's room and not yours? Because we had said he had asked me, Vic had asked me to come to his room to see the video in front of Stan. Ask you a couple of questions. I understand. Why would Vic have initiated anything? I don't know. I can't answer that. Couldn't Stan have come to the door at any moment? I don't know. But it's possible. I mean, he could have come at any moment. I have no idea what Stan's plans were that day. All right. Okay, appears to be an article on Polygon. Contacted by Polygon. Let's see. Anime News Network. Wait a minute. Where's her stupid story? Oh my god, this is annoying. This is probably way more annoying for you than for me. Maybe I was at the end of it. Okay, here we go. Okay. And in this tweet where you say I went to a friend's room and he grabbed me by my upper arms and French kissed me, there's no mention of him pushing you on the bed, correct? No, I think I saved. I didn't post the details at that time. No mention of Stan knocking on the door. Didn't post the details at the time. Switch gears a little bit. Okay, where? I want her to tell the stupid story. Oh, here we go. Chose not to tell Ron. Where is this? All right. Well, this is annoying. I'll have to find it later because I don't want to. Otherwise, I'm going to sit here and say this over and over again, or read through this over and over again. Oh, that's a jelly bean story. Wait, oh, here it is. Oh my god. Sorry. Finally. Okay. It's been flirting with a gentleman named Raleigh Pickens. This is the best TV ever. And Vic would come and join us on occasion, kind of didn't seem to realize that we were doing our little flirting thing. And Sunday, when they all left, Standall in the convention chair had said, you know, we're going to all go out to dinner with the staff and we'd like for you guys to go. We agreed. Then Vic said, hey, can you come by my hotel room? There's something I want to show you. I can't recall exact. I think it was a Full Metal Fantasy film that he had done, his fan film. So I went to his hotel room because, like I said, I had been flirting with Raleigh all weekend. He was dating a friend of mine named Michelle Speck. That's why you go. Isn't that the reason? I was flirting with a friend, Raleigh, and he was dating, I was flirting with Raleigh, and he was dating Michelle Specht. That's why I went to his hotel room. Perfect. So I went with him to the hotel room. Boom. He played for me the video, and in the middle of the video, he grabbed me by the arms, and he turned me around, and he started kissing me. And sorry. And it's okay. I was raped when I was 15 years old. So for me, it was a very difficult moment. I was frightened. I was scared. I didn't know what to do. When I was 15, notice all of this is irrelevant to the story. I'd fought back and that didn't end well for me. So just kind of went along with it, knowing that any minute Stan was going to come to the door, and he kept kissing me. Now remember, any minute Stan was going to come to the door. Later she asks, couldn't Stan have shown up at any time? I don't know. I have no idea. I have no idea when he could show up. And he kept kissing me and kind of pushed me back onto the bed and actually got on top of me. And I still have like a very visual, like a nightmare actually, that feeling of looking at the door and thinking, how do I get out of this? Like how do I get out of there without ruining the friendship that we'd have? Very concerned about the friendship, trust that we had built. And then Stan came to the door. When Stan came to the door, he jumped up and ran to the door, and I kind of covered my face because being pale, if anything is happening to you, you can see it all over my face. Stan came in, he asked me as we were leaving, are you okay? I said, oh yeah, I'm fine. And just kind of kept covering my face. Now, I'm sorry. Mr. Dolan inquired whether defendant was okay, clearly noticing distress. Defendant, however, was too shocked and afraid to admit what had occurred. And we went to dinner. I don't recall where we went or what was spoken about because I think I was in shock the whole time. When we came back, he went outside of his room. There was this little patio. And he was standing on the patio and he called Michelle. And he put me on the phone with Michelle. That was hard for me. So there you go. There's the two stories. Here she indicates something. Oh, yeah, I'm fine. And just kind of kept covering my face. I'm good, yo. No, I'm fine. I'm fine. Leave me alone. I'm good. Stan came into this one, and this one I don't think he came in. Let's see. That's weird. Anyway. Okay. So there's that. Well, you guys don't do this? You don't say you're fine like this? I'm fine! Can't you see? No, the hotel room, the hotel they were at does not have patios on the rooms. Death Ralkin. Thank you for bringing that up. No. I like the Spike Man says, spent $50 on lunch this morning. Have you ever had unagi? Eating my leftovers and even heated up, it is amazing. I've never had unagi, no. We will stand with Vic, Uwu, Kamochi. Thank you, Nick Sama Kawaii. There you go. There you go. All right. So, have they put any clear and specific evidence of a prima facie statement? I mean, they've got her admitting to the tweet. They've got the tweet referenced in the interrogatory. I don't know what else. Did she make a statement? Yes. On Twitter? Yes. Is it false? Vic says it's false. Therefore, when you look at it, does it tend to hurt the reputation of the person? Is it defamatory? Yes. Is it made with actual malice? Well, again, Vic and Monica are the two people who know what happened in that room. Therefore, if he didn't do what she said he did, it's defamatory. Period. He's denied all of it. And is it included in the filings? Yeah. It's the one that specifically Judge Chupp allowed in. Right here. I mean, I'm sure it's elsewhere in this monstrosity of evidence. There's all sorts of stuff about, you know. Oh, God, I'm sorry. There's all sorts of stuff in here, but it's so many pages that I don't want to go through all of it. Oh, there's also the affidavit of Chuck Huber, but whatever. It doesn't really matter. There's also Chris Slatosh saying that Monica was on the phone with him. I guess we should cover that real quick, because these are... It's Erica McCord. What? Who's this? Faisal Ahmed. Ew. Slatosh. So here we go. Participated in a telephone conversation with Rial in which she repeatedly asserted that Vic was a sexual predator. Criminal charges would soon be filed against him. She also implied, and I inferred, that she would convince numerous other voice actors to cancel their appearances at KamehamehaCon. So again, this here is also a defamatory statement made by Monica Rial to Chris Slatosh. And it's in evidence. Well, it was withdrawn. This one is the questionable one, because anything in these affidavits, the appeals court has to determine that Chup was wrong in removing the affidavits, or the unsworn declarations, as it were. I think he was, but we'll have to see. Although, I should point out that the affidavits and the unsworn declarations are actually filed in the defendant's motion as well. So, I mean, they also filed them. They're also there. That's interesting. But, okay. Okay. So then the last one is Ron Toye, and all of Ron's tweets are in this document. This one is the easiest to show that I mean, there's prima facie case of defamation. Let's see. Let's find an easy. This is this is implied defamation per se. I never said he raped someone, but sexual assault can be a wide range of unwanted physical contact. Okay, so there you go. Prove Vic didn't assault her. Now worried about me, he didn't assault me. Let's see. Court battle, let's see who walks away a registered sex offender. Just because they were nice to people at cons doesn't mean they can't be a person who will sexually assault their friends and coworkers. I mean, these are all defamation per se. They're talking about Vic. And again, if they want to try and argue, because they tried this in court, they tried to argue that the context of all these tweets isn't provided. So without that context, then they can't prove that this is about Vic. Well, this is prima facie. They allege that this is about Vic in context. Then that's the prima facie case. They get to argue if the context said it was about someone else. I'd love to see that. But notice they haven't said it's about someone else. They've said, well, they didn't show it was about Vic. Look who isn't afraid to tag your alpha, Vic Mignogna. You think you know what beta and alpha are? I run a company. The other can't even find a library con that wants him. Wow. This is actually false, and, well, I guess maybe a library con might not want him. I don't know. Are there library conventions? But anyway, sorry. There's a whole bunch. But my point is, this is all in the record. Oh, look, I bet he's not talking about Vic here. Anyway, these are all in the record. They're filed. There's no way there is not a prima facie case. And I believe the first ones are specific responses to Vic, and a lot of these are just supporting and going on from there. What is this? Oh, wait, here we go. Here's the other telling. So this is in here too, by the way. Here's Monica's original tweet about it. Sorry, I didn't realize this was in this monstrosity of a document either. Convention together, grabbed me and kissed me. I froze. You may wonder why I didn't yell or scream and push him away. Why? Because I was raped as a teenager. He asked me to watch a video because he was my friend. Not only that, but he was dating my friend Michelle and flirting with my I was flirting with my soon-to-be boyfriend at the convention all weekend. After that, I distanced myself from him and unfortunately Michelle as well. I felt incredibly guilty even though I hadn't done anything wrong. Blah, 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 blah. I guess we have all this right here. So here's all this stuff. Here's where the investigations are incredibly thorough. So they do have, I mean, they have defamatory tweets from Monica as well. And notice how the story has evolved. I went to a friend's room who was in a committed relationship and he grabbed me by my upper arms and French kissed me. That is inappropriate. That's how it started. Then it evolves into this story. So anyway, there's all of this stuff. This one is a reply to Vic Mignogna. They're not false. 4 people are very close to me, have been assaulted by him. Didn't know this until a few days ago, or things would have been much different in LA. Yeah. Big tough guy, Ron. I can't speak to all the accounts of people who have come forward with their personal experiences with Vic, but I know with 100% certainty that he assaulted 4 people I love. I'm sorry to all the people he has hurt, and I stand with the victims. So there you go. If nothing else, there. 100% certainty that he assaulted 4 people that I love. There it is. That alone is a defamatory statement. And it's right there. It's in the filing. It's in the filing. Okay. I can go on, I guess. There's more to this, right? We can do this with the TI, and I may do that later. I want to point out, I wanted to go through some of this stuff for some specific reasons, okay? There are people who suggest that because the second amended petition wasn't admitted by the court, that he doesn't have a case. That because those things weren't in there, that there isn't a prima facie case. But the prima facie case is there. It's in the filings that Chup says he admitted. So when they go to the appeals court, what are they going to do? They're going to point to the places in the filings where they are. Remember, this document, this is not a great filing. I've said this a couple times. But the plaintiff's response to defendant's TCPA motion to dismiss, it's not a great filing, but it does have a massive amount of evidence. Now, it is 1,200 pages or whatever, which is ostensibly ridiculous. However, importantly, 370 of those pages are Ron Toye's tweets, and about 600 of those pages are the transcripts. So even if you just skip the transcripts and go to the actual tweets that are included, you'll find the evidence in there. It's in there. And if it's not there, it's here, or in the amended petition. Or in like I said, and Funimation has this stuff in theirs. It's in their affidavits. They admit to making the statements as well. So to suggest that these things aren't in here, at least with regard to the defamation, is silly. And whether or not the appeals court, here's the risk for Vic on the defamation stuff. The appeals court, well, the risk is that they dismiss everything and just go on. They just agree with Chup and dismiss everything. That's a risk, obviously. If we think the appeals court is going to thoroughly look at all the filings, go through all of this stuff, and with the help of the appellate briefs, point to the evidence that's on the record, if we think they do that, okay, and if the filing is done properly, if it's a good filing that's well drafted, and I'm not drafting these documents, I'm not in control of what other people do, so who knows? But if it's a well drafted filing that cites to where in the record all of this stuff is, because just now I've shown you what's in the record for defamation for all four parties, right? It's there. So all they have to do is point to it for the appeals court and say, here's this, here's this, here's this, here's this. This is a prima facie case for defamation because here are the elements and here's how this fulfills it, okay? So you just boom, 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 boom. Lay that out. Now here's where the appeals court may ghost them if they do that thorough work and go through, they may determine that these aren't sufficient showings of actual malice because they may determine, for example, that Kahn versus van der Linden is very narrow and that it can't apply to some of the defendants in the way that they would want it to apply. They may do that. They may do that. But either way, they're going to have to look at this and say, there is in the evidence a showing that this and this and this and this are there, but not this. Because this point of law is incorrectly applied. If we apply a lot of these facts, it doesn't work out. That's the negative case if Vic gets what I would consider a fair read from the appeals court. Now, it is possible the appeals court just says, nope, peace, you're out. Appeals court can do that. And then you have to try and get it to the Texas Supreme Court. At that point, you're really pushing low odds. Low odds. It is possible the Supreme Court would take up your appeal. It's low, right? Supreme Courts get to choose their cases. And there has to be a controversy. It's actually probably more likely if the appeals court does a really big read and then takes issue with van der Linden versus Kahn and says that van der Linden versus Kahn is not applied correctly here, then they can raise that issue to the Supreme Court and say the Supreme Court needs to clarify this ruling or whatever. They can try and do that, and that's more likely. If they just say dismissed on everything, the Supreme Court, that's not leaving them much of an issue to take to the court, and that'll be a problem. So we'll have to see how they do it. Like I said, I could go through the TI, I could go through the conspiracy, but I don't really want to tonight. It's already getting kind of late. So I think what I'm going to do is I'll do the super chats and wrap it up. And we'll see how things develop. I'm expecting a ruling in Meyer versus Wade over the next couple days on the jurisdictional argument. That's due. I think the 16th is like 30 days from when it was referred to the magistrate judge. So hopefully we'll have a ruling on that coming out. A ruling from the magistrate, and then of course they'll have their opportunity to disagree with the magistrate or agree with them. And then they'll probably try and file a TCPA motion, even though the Fifth Circuit currently says it doesn't exist. We'll have to see. They'll probably try and file one anyway. But I'm expecting a recommended order from the magistrate in Meyer versus Wade very soon. I'm watching for it every day. Other than that, we should have some more guests coming up soon. I'm saying this for those of you that leave during the super chats. If you do hang around for the super chats, thank you very much. And we'll do those in just a second. What timeline are we looking at for appeals response by? I think we'll see an appeal being filed in the next... I think the most conservative estimate is they only have about 10 days left. Oh, by the way, there's a bald dummy out on Twitter suggesting that Ty would file his appeal early. Here's this interesting thing. So what? It's mildly annoying to file an appeal early, but Texas rules appellate procedure. Pull this up real quick. Rule 27.1, I think it is. Prematurely filed notice of appeal. In a civil case, prematurely filed notice of appeal is effective and deemed filed the day of, but after the event that begins the period for perfecting the appeal. Okay, so there's ambiguity on when an appeal has to be filed. There's a time limit, 20 to 30 days. 20, depending on if it's expedited, it's 20 days. If it's not expedited, it's 30 days. Either way, they have a time window following a final ruling. Don't know if the final ruling started when Chup wrote his order, this order right here on TCPA, if this is a final ruling, or if the final ruling includes the sanctions and attorney's fees ruling that's going to come prior to that. Here's the thing. You can file now. You can appeal now. And you can go ahead, because we know he's got to award sanctions and attorney's fees. That's in the law. How much he orders is a question that would be argued back and forth. But if you're appealing, you know how much is, or you know what the ruling is. So this might be the final order signed by Chup, or the other thing might be the final order. What you do is you err on the side of caution and you appeal early. And then if you have to wait for the appeal to be perfected by a final ruling, you've already got the appeal and the rules allow that to go on. So you err on the side of caution in the face of the ambiguity. You file the appeal early. So I think we're going to see that appeal coming probably in the next 10 days or so. But we'll see. We'll see. So there's that. That's the timeline on the appeal. I'm going to switch back over to Hangouts here. Oh, sorry. Hangouts is on my label. Never mind. Ignore me. Ignore me. I should change that name now. Because it no longer applies. But I'm going to do the Justice Chats and Super Chats. I will go on Twitch after this. I'm not sure what I'm going to do on there, but come hang out if you want. We'll start with the Justice Chats. Tinlay says, "Hi Nick, I'm glad that Vic is going to appeal and you'll cover it. Also, channel is quite known for 40k and anime, so your opinion on 40k's anime-inspired Tau Empire, like them and play through in Dawn of War." I'm not a huge fan of the Tau. And I hate playing them in Dawn of War, especially for their campaign, because they just don't... I don't like it. Although the Zerg Rush of the Vespid stealth suits is pretty fun. But other than that, I'm not a big fan. Or not the Vespid, just the regular stealth suits. Because you can make like infinity of them, and then just send in a whole stealth... like 1,000 guys just ruin someone's day. It doesn't take away from your infantry cap. I like that. That's funny. But other than that, I don't really care for them. Janie Marquis says, "Big yikes, appeal's a mistake. Vic should do what everyone wants him to. Just give all the GoFundMe money to Monica and I mean Jamie, and the casting couch thing is overblown. Sabbath was finished before I knew he was in me." Oh, gross. I'd have Annis on, or Nerdrotic on to talk about Annis. Sure. Mercenary X says, absolutely not. I will not respect Chup because he has no idea what reality is. Will Wright of SimCity fame asked his child if he understood what he was playing wasn't real. His son said it's just a game and shouldn't be taken that seriously. He was 12. So there you go. Magnus Borson says, fun fact, I was at a con in the early 2000s with Vic and Rial in attendance. She was all but throwing herself at Vic. It was obvious to everyone in the signing room. Now, I may or may not have heard rumors about Monica Rial being attracted to Vic and all that. I may or may not have heard that, about consensual activity between them. I don't know. Who do you believe anymore? Who do you believe? I know who I definitely don't believe, personally. Hellsnake says, Arabian Nights, like Arabian Days, more often than not, are hotter than hot in a lot of good ways. Why are you quoting Aladdin? Night of Hope X says, I bet TCPA is protected by gentleman's agreement by Texas judges as politicians, allowing them to throw out cases they don't like, don't want to rule on, and pretend at election to have no responsibility. Chup might not want to be the guy to get it struck. Won't be up to him. Jay said, there seems to be a rhetorical element to appellate briefs. What framing do you think would be the most effective? Also, do you think there is argument to be made about how social media exacerbates these sort of things? I think one of the arguments to be made is if people are allowed to make statements that are false to third parties, knowing that they're false, to cause damage to someone and have that not be defamation, then defamation is dead in Texas. And maybe the Court of Appeals is okay with that. Maybe they're okay with that. But I think that's the rhetorical framing that you go for. If these things that happened and caused damage that we can measure aren't defamation, then what is? Then what is? Argument to be made about how social media exacerbates these sort of things. Yeah, I think that you would argue that I don't know if this is an appeals court argument. This is more of a jury argument. But you argue that they knew exactly what they were doing, that they intended the damage to happen. That's why they did it on social media. They feared that they could not substantiate their claims, which is why they didn't ever go to the police or anything else. Okay, Mercenary X says, sorry, it was a 10-year-old, not a 12-year-old. That's besides the point. How pathetic do you need to be? There's a 12-year-old has more common sense than a supposed judge. Judge can't tell fantasy from reality. How pathetic is Chup? Donald Toye says, I agree with you, Nick. Vic should drop the lawsuit, give all his money to Monica and run, admit he's a dirty dog. Monica is forgiving. After 5 years of exile and unemployment, she'll consider allowing him to attend a convention. And Donald Toye says, this isn't Ron. Oh, perfect. Good. And then Night of Hope X says, thinking back on it, nearly every question Jub asked, even the first hearing conversations with Ty, was aimed at disinvolving the court. It's actually kind of cartoonish now in context how he ended up ruling, ducking from the very beginning. And again, if you may think, people are free to say that Vic didn't have a case, that this is stupid, that defamation cases are impossible, all that stuff. They can say all of that. They're free to do it. But if they try and pretend that Chup's ruling is anything other than amateur hour, they're lying. Frankly. You can say Chup ruled correctly, but that ruling was garbage, and be honest. If you say Chup ruled correctly and that ruling was great, or that ruling is definitive and perfect, you're lying. If you say that ruling was reasonable, you're lying. The ruling is objectively bad. Whether or not Chup came to the correct conclusions, those are two different things. I think he came to the wrong conclusions, and he gave the appeals court a lot of leeway in determining that he came to the wrong conclusions. But we'll see. We'll see. Okay, next we've got Gengyo. Finally have money to super chat and do a bit of drinking again. Some Basil Hayden's to celebrate. Hey, nice. Skull, brewer. Cheers, brother, to my new job. Hey, congrats, buddy. There's nothing in here. Hold on. All right. Gotta get through this military special. Congrats, buddy. SJW Slayer Leo says, did intern Chan relay my DM to you? Please do it. I'll check with her. Maximus Grove says, hey Nick, what size t-shirt do you wear? I'm sending you banned in China from our line at Side of Epic. Reddit banned our ads, so I'll stick to super chats. Everyone else, 20% off with code Rekieta. Hey, there you go. So check out Side of Epic. A banned in China shirt? That would be great. What size t-shirt do I wear? I hover between medium and large. Depends on the shirt, mate. Let's go with a medium, so I look like I can pretend to have muscles. Conspiratorial Walnut says, dunno, I'm pretty animated about this case. Fading Shotten 1, thank you for the donation. Thane Cotter says, Mark Kern is making a game using voice acting. Oh, maybe he is. Maybe he is. Melidius says, Nick, any idea if Vic would narrate an audiobook? If so, I might want to add that to the plans for my book. Hoping for a 2020 release. If I can get focus again, 30k words of 90,000 word goal. I have no idea. I would imagine Vic would seriously consider any professional proposition sent to him. I would highly advise against saying, hey, I'm going to maybe finish my audiobook. Would you voice it when I do? Get a book written, put together a proposal to hire him to do the audiobook like you would anybody else. That's how you get these things done. If you're gonna approach especially someone who's been working in an industry for 20 years, if you're gonna propose a project to them, propose a project with a timeline, with a budget, put all of that stuff together, get it done or get it ready, get it to the point where their involvement is literally, yes, I will do this thing that you're hiring me to do. Let's schedule it. And then propose it. If you're not done with the book, hold off until you are done with the book. That's all. Dark1005 says, Nick calling Vic's pants gay. Talk about the pot calling the kettle ninja, Mr. Short Shorts. Hey, those shorts can get shorter, buddy. Random Blaze says, everyone say it with me. Oh, hi, Mark. The low T stooge live tweeting the stream with his unbiased opinion. Oh, gross. Finfrog says, John Kelly's leak of your Discord was more like a free ad on Twitter for your YouTube channel. To celebrate, unfortunately, it had the lowest reach of any ad possible. To celebrate Vic not rolling over and dying, I ordered a Big L t-shirt. Good. Good. Buy the L's. Vince Garrett says, I like how the blood veins pop out in your neck when you explain the way things work in the real world, Professor Blood Pressure. Finfrog says, it's absolutely hilarious that Law Twitter is full of idiots that are obviously chasing #MeToo clout. It's not just hilarious, it's also a little bit embarrassing. TLJ Screwjob says, is that last knife the Drexel or the Nick? Definitely the Nick. Jason of the Great Awakening says, Nikki, can you wield the big knife, give a cheesy grin, and stay still waiting umbrella guy? I guess we can do that. Still waiting, umbrella guy. Hopefully that worked for you. Okay. Armchair Warlord says, is there a constitutional due process issue with TCPA? If I read it right, it invites courts to make fact findings on affirmative defenses pre-discovery. I mean, yes, but the Supreme Court has ignored that. The Supreme Court of Texas. So, there you go. Name says, who wears gay shorts? Nick wears gay shorts. Rude. Marius Van says, on a scale of 1 to 10, how much better is your life now that you're off Twitter? 7. Probably. Objectively 7, but it is mildly less fun. Nathan Kish says, even if Maronica wins, they've still destroyed their image and reputation. Vic, however, is still employable, win or lose. Vic still wins. Am I wrong? I don't think you're wrong. D-Man DOG 056 says, if Vic's appeal is success, Marquis gets deposed. It's not guaranteed because it depends on how the success works out. But if Marquis is kept in the suit, even on one count, and that keeping in the suit moves them past TCPA rather than just remanding it to Chup for a do-over, then yes. If they remand it to Chup to have him do the TCPA hearing over, to do it properly, to resubmit the filings or whatever, then that's up in the air. Although they probably won't do that. Chup made so many weird errors in his ruling that they could either remand it or overrule him entirely. We'll see. Name says, who'd win? Rial's horse bites or Arms Girl's spin slap? Oh, man. I think Arms Girl's got the reach. Cloudfire 181 says, hey, Nick, if you want that interview with my dad, please contact me ASAP by email, or we'll have to wait till December. Good night. I will. I saw your email, pal. I'll get back to you. Ben says, cheers, Nick. I'm drunk. Bottom text. Attaboy. No one important says, hey, Nick, whenever you upload 2+ hour streams, seems to cut off some of the beginning. I was wondering if there's any way to fix that. Thank you. It doesn't actually cut it off. There's just a processing period that YouTube processes the video and makes it available in multiple resolutions. And that process takes a couple hours. So if you try and watch the 2+ hour streams right at the beginning, only the final 2 hours are available. Once it finishes processing, usually in a span of 2 to 3 hours afterwards, you can actually watch from the beginning. So there's nothing I'm doing. That's how YouTube handles it. Rick Nikita says, all of my alarms for work were set to silent. Pray for me. The Emperor protects. Good luck, buddy. Good luck. Eric R says, con sluts. Mario Carter 13 says, Vic assaulted someone I love to assault. Soye. Oh, no. Super Range 128 says, how/where'd the late and gay meme even start? I don't know. Sketch Therapy says, only after Rekieta. Cecil is leaving us. He's not mad. They made him an offer he can't refuse. Come by and say farewell, sir. At Rekieta Law. Cecil is leaving. Where's he going? Horatius 763 says, wasn't the law invented by Anglos? Non-Anglos care? I think so. Ultimate IRS says, everyone remember to back Imp Story on Indiegogo. That is Cody Bayer. Cody from Anime Outsiders. I can never ever say his last name properly. Cody's Indiegogo campaign. I may have him on to discuss it. It kind of depends on how things unfold. So, all right, guys, that's the stream for tonight. Oh. Okay, hold on. Knight of Hopex says, oh yeah, that raises an interesting question actually. Oh, let me turn on the music. Here's the outro music. Oh my goodness. I boomered that. Hold on, I'll start it over. There we go. There's the outro music in the background. That signals the end of the show is near. The end is near! Thinking back on it, nearly every question Chup asked, even in the first... Oh wait, I read that one. Oh yeah, that raised an interesting question actually. Can't literally everybody who has defamed someone in Texas cite this ruling forever if the appeals court upholds the ruling? Yes. Doesn't that literally undo the law entirely unless the Supreme Court overrules? Not really. Not really. They would just, like the other rulings, suggest that not enough evidence was presented. Granted, they will never tell you what is enough. It's supposed to be prima facie. And I want to point out, this has been appealed. This particular issue of the law, prima facie showing by clear and specific evidence, has been appealed over and over and over, all the way up to the Supreme Court. Courts continue to get this one wrong because it's such a weird standard. Because you're asking a judge to see evidence prior to when they would normally see evidence, and they're not used to doing that without asking the other party to weigh in on the evidence. But they're not supposed to do that. So then they get in this weird question, is it enough evidence? Is it not enough evidence? Is it sufficient? And they have another argument coming at them saying it's not sufficient because of this, this, and this. They're not supposed to have that. That's kind of the weird problem with this law, and that's why one of the reasons it keeps getting appealed and keeps getting clarified by the Supreme Court. An appeal of a TCPA, this is not outlandish at all. Hellsnake says, hold the knife and sing the song and you will know why. Oh, the Arabian Nights. I get it now. I get it now. No, I'm not going to sing Arabian Nights while holding the knife. But thank you for the sentiment. All right, guys. All right, guys. I missed your super chat. Oh! Yes, I did. JCF Data says, why the heck did she go back to his room after dinner if she had been assaulted in order to be able to talk to Michelle on the phone? Listen, Michelle was her friend. There was no way she could talk to her on the phone on her own. No way. And she also felt compelled by his power to cover for his behavior, even though he not only just assaulted her, she wanted to preserve the friendship, and she also didn't want to let Michelle Speck know that Michelle Speck was getting into a relationship with an assaultive, abusive person. I guess. I don't know, man. It doesn't make sense. These actions, of course, don't make sense. These people are irrational, I guess. Name says, breaking news. Here's a super chat to delay you. Thanks, buddy. The Geek Conservative says, NBA wants you to wear shorter shorts. Hey, no. Austin Heartless says, delaying super chat. Oh, my goodness. All right, guys. I'm going to wrap it up for tonight. Come join me on Twitch. Come hang out over there, and we'll see you soon. Peace.